Hello friends, in today's session we are going to discuss the case of Messrs. Construction India vs. Secretary Works Depot, Government of Orissa and others. Let us first understand this case briefly. This dispute centered around Section 30 of the Arbitration Act. By mutual agreement of the parties, Mr.G.V.Patnaik was appointed as the arbitrator. The respondent objected to his jurisdiction after his retirement, but the trial court rejected the objection. However, the High Court accepted it. The Supreme Court clarified that if an arbitrator is appointed by name, his jurisdiction does not end merely upon his retirement from office. Additionally, withdrawing an objection during proceeding is considered acceptance of jurisdiction. The Supreme Court upheld the arbitration award, allowed the appeal, and set aside the High Court's decision. Now let us study this case in detail. Answer: Messrs. Construction India, Appellant vs. Secretary Works Department, Government of Odisha and others, Respondent. Reference 1998 to SCC 89. Subject matter: this case is based on Section 30 of the Arbitration Act. It clarifies that if an arbitrator is appointed with the consent of both parties, their jurisdiction remains unaffected even after their tenure ends. Facts of the case: the appellant entered into a contract with the respondent for construction work, which included an arbitration clause. When a dispute arose, the plaintiff filed an application under Section 8 of the Arbitration Act to appoint an arbitrator. On 15 September 1981, with the consent of both parties, Mr. G.V.Patnaik, chairman of the Arbitration Tribunal, Orissa, was appointed as the sole arbitrator and the dispute was referred to him. The arbitrator initiated the arbitration proceedings, where both the appellant and the respondent presented their claims and counterclaims at different stages. Later, the respondent filed an application arguing that Mr. G.V.Patnaik had retired on 19 February 1982 and therefore he no longer had jurisdiction to continue the arbitration. However, the respondent's counsel did not strongly press this application. As a result, arbitration proceedings continued and the arbitrator dismissed the respondent objection, stating that it was not insisted upon. After completing the arbitration proceedings, the case was reserved for the final order. Ultimately, the arbitral award was passed on 17 March 1982. Subsequently, the respondent filed an application in the court to set aside the award, while the appellant sought a decree based on the award. Trial court's decision: the trial court provided both parties with an opportunity to present their arguments. During the hearing, the respondent argued that the arbitrator no longer had jurisdiction after retirement, so the award should be set aside. On the other hand, the appellant contended that the arbitrator was appointed with mutual consent and after recognizing his jurisdiction. The respondent could not later challenge it. Considering these arguments, the trial court rejected the respondent's application to set aside the award and ordered that the arbitral award be treated as a decree. High Court's decision: the respondent appealed against the trial court decision in the High Court. The High Court ruled that once an arbitrator retires, their jurisdiction automatically ends. Hence, the arbitrator had no authority to conduct the arbitration proceedings after retirement. Based on this reasoning, the High Court accepted the appeal and overturned the trial court's decision. Supreme Court's decision: the appellant then filed an appeal before the Supreme Court. After hearing both sides, the Supreme Court clarified that the appointment order explicitly indicated that Mr. G.V.Patnaik was appointed as an arbitrator by name and not merely due to his official position. The order did not contain any clause stating that his arbitration authority would cease upon vacating the post of chairman of the Arbitration Tribunal, Odisha. The court also observed that parties choose arbitrators based on their expertise and experience. When an arbitrator is appointed by name, their jurisdiction does not automatically end just because they leave their official position, unless there is a specific clause in the arbitration agreement stating otherwise. Therefore, the argument that his authority ended upon retirement was not legally sustainable. The arbitration agreement itself established the arbitration jurisdiction, which was mutually agreed upon by both parties. The records clearly showed that although the respondent initially raised an objection regarding the arbitration jurisdiction, they later withdrew their application and continued to participate in the proceedings. This indicated that the respondent had accepted the arbitrator's jurisdiction and had waived any objection. Furthermore, the court held that a minor clerical error such as an incorrect date in the arbitration records does not provide sufficient grounds to invalidate the entire award. Such minor errors do not affect the legal validity of the arbitral decision. Final judgment. Accordingly, the appeal was allowed and the High Court's decision was set aside. The Supreme Court ruled that the arbitrator had the legal authority to conduct the arbitration proceedings. Hence, the arbitral award was valid and binding on both parties, and the appellant was entitled to a decree in accordance with the award. Legal principle established. Point 1. When an arbitrator is appointed by name, their jurisdiction is not affected even if they retire from their official position. Point 2. If a party raises an objection regarding jurisdiction but later does not insist on it and continues with the proceedings, it will be deemed that they have withdrawn their objection. Point 3. A minor clerical error such as an incorrect date in the records is not a valid reason to set aside the entire arbitration award. Please watch full video, share and subscribe to the channel. Thank you.